One of Mr. Beast's former employees signed a non-disclosure agreement, which included a confidentiality provision in there, and now he's going around the town sharing all of Mr. Beast's business. So one of the questions everyone is asking is he going to get sued? Is he allowed to do that? And realistically, what happens and what are your legal rights and obligations after signing a non-disclosure agreement in the state of California as an employee? Hi, my name is Adam Juratovac, and I'm an employer right here in San Jose, California at Juratovac Law. And in fact, I'm an employment lawyer. So these are the types of issues that I handle every single day at work. If you're here, then you're already going to know that this is going to be a one-take video. So I'm just giving this thing one shot, one cut, and sending it off. But if you also were here earlier, you're going to know that I tried to create a first video where I only had around 10 minutes before a consultation, and this is going to be my second one. So I have a little bit more time. Doesn't mean I'm going to take it, but I'm going to have a little bit more time to slow things down and really talk about the main points. So we've all been seeing it lately where we've seen Mr. Beast in the news for a variety of reasons having to do with him, his employees, and the companies that he works with. And if you know who Mr. Beast is, he's one of the biggest personas on the internet. He's been on YouTube for a while and has millions and millions of subscribers. So one thing that we've been seeing lately, what's been going on, is you had a former employee who has released a video or a series of videos talking about all of the things that he believed were wrongdoings, unlawful happenings, or straight things that were happening that were illegal while he was working for Mr. Beast, and also what he believed some past policies and practices that they had were also illegal. Now, the one tricky part here is allegedly that former employee signed some type of non-disclosure agreement. Maybe it was in the employment agreement, and maybe it was in the severance agreement. I would say or a settlement agreement, but from what I heard, he's only been working there for about a month before he was terminated. So double check on that. So I'm assuming he signed something right when he started. But for the intents and purposes of this video, I'm also going to talk about what happens when employees in California sign a severance afterwards, after their employment ends, and what those legal obligations are. So the first thing we're going to have to talk about is what are these provisions that people are talking about right now in employment contracts. So I'd say the three ones that we're going to focus on here, because this is not a video about every provision in a settlement or a severance agreement, but the ones we're going to focus on here is about non-disparagement, which is, we'll explain in a minute, non-defamation, non-defamation clause, and no slander clause, and also confidentiality about what happens in the workplace. So the first things first, slander and defamation are already illegal because both of those have to do with the speaker, the giver of the message, giving a fake or a false message, giving a lie, talking a certain kind of lie about someone that has to do with a certain number of properties. So think about when someone is defaming or speaking poorly in a lying statement about your business acumen. You can't do that, right? And speak as if it is a fact. So slander and defamation are both about things that are incorrect, right? They're false. One's written, one's oral. And then when we look at defamation, that's when it becomes a little bit trickier, because with defamation, you could be telling the truth. But if you sign a contract or a settlement agreement or a severance agreement that has a defamation provision in there, it means that you're not allowed to speak anything negatively about the company, and then it'll usually have a list of about 15 other parties that are also included in that non-defamation provision, which is probably going to be like the board, executives, employees. I already said executives, vendors, third-party contractors, essentially anyone that the company knows or is connected to under the sun. Those are all the people that you cannot defame, or, in 2024, those are all the people that you can't talk trash about, even if it is true. So that's what that provision about you can't defame the company, that's what that's talking about. Now, when we're looking at confidentiality is a little bit different, because when you're working at an institution, you're working at a company, and, over here in the San Francisco Bay Area, there's a lot of companies that, need to keep their information confidential and need to keep a lot of what they're developing confidential. There's a lot of biotech companies here. There's a lot of startups. There's a lot of different types of tech companies here that are trying to build the new, greatest and latest now AI. So a lot of companies still want to give an individual a confidentiality provision in their employment agreement, and then if the company gives the employee a severance later, the company still wants to have another confidentiality provision in that severance agreement, so that you're not able to share anything confidential that happened at the business. So those are some of the provisions that are in these severance agreements and employment contracts. So as you can see, the non-disparagement provision is pretty expansive, because you're not allowed to talk trash about your employer to anyone. There are exceptions to that, but when you look at that one provision in the settlement or a severance agreement, it doesn't tell you necessarily what the exceptions are. So one thing I always tell my clients is, don't do what this alleged former employee of Mr. Beast did and create a whole video reading your former employer to filth. But at the same time, the reason I tell them that is because they have the right to do that in certain situations. For example, just recently, the National Labor Relations Board issued an opinion letter stating that confidentiality provisions and non-disparagement provisions in severance agreements are far too broad, and they are way overbroad. Because, for example, just from the explanations of non-disparagement, confidentiality, and non-defamation that I've shared with you, you can't say anything about your employer. But we have something in the Constitution called free speech, and although that speech is limited and confidentiality agreements, trust me, are absolutely enforceable, we have laws and regulations in this country that tailor down the power of confidentiality agreements. So what was just stated in that National Labor Relations Board letter was, after it said that these policies or provisions are way too broad, it recommended that all of these settlement agreements and severance agreements include language that say nothing in this agreement or nothing in this provision prohibits you from engaging in protected activity under the National Labor Relations Act. Now that sentence it doesn't have to be included, right? But it was guidance that something narrowing the scope of the confidentiality provision needs to be in there, needs to be in the contract now, which is great, because if you're not a lawyer, you're reading the contract and you don't know what they're allowed to put in there and what they're not allowed to put in there. You don't know what's enforceable and what's not enforceable. So I'm glad they have to write that in there now. That just came out like March 2021. No, sorry, March 2022. Or was it March 2023? It was before I moved in San Jose. But either way, coupled along with that, there's a new law that came out in the state of California. Now, before we talk about the new law, I want to give you a little bit of the history about it. Back when the Me Too movement was progressing, back in 2015, 16, we passed something called the Silence No More Act, meaning that if you signed a settlement agreement or a severance agreement, but you alleged sexual harassment, sexual assault, or sex discrimination, those three things couldn't be subject to a confidentiality agreement in the employment setting or in any setting. So let me say that again. We had the Silence No More Act that said if you're an employee alleging sexual harassment, sexual assault, or sex discrimination, those could not be subject to confidentiality into an agreement. Now, the state of California realized that, maybe we don't want only sex discrimination, assault, and harassment to be the only things that employees can talk about after the fact and can't be subject to confidentiality agreements, because technically sex discrimination is very similar to race discrimination in the way that the eyes of the law sees it. They're discrimination and harassment. So in the state of California, we expanded it to now any unlawful acts that occurred at work cannot be subject to a confidentiality agreement or cannot be waived in a severance agreement. And now it's actually required in the state of California that your severance agreements say that you're always able to talk about unlawful acts that you reasonably believe are unlawful with employees or outside of work, and they cannot be subject to confidentiality. Pretty strong laws, right? Pretty strong laws. I think the National Labor Relations Act was expanded so that you're always able to talk about protected activities, and you're always able to interact and engage and talk about your working conditions and your workplace conditions with others, especially when you're trying to make it better. And then with California, now we have to say that this confidentiality provision does not apply to any unlawful act that occurs at work or that the employee has reasonable belief is unlawful. So this guy in the YouTube video, how many times did he talk about activities that Mr. Beast's company was completing that he believed was unlawful? So you see that correlation there? So one reason I tell my clients who, if they ever sign a severance agreement, I always ask them a bunch of questions about who they want to talk to about this, how they feel, if they feel heard or not. And also, what are their plans? Because before they sign an agreement that signs away their rights and where they have to be, they have to engage in certain activities in the future, I want to find out what their goals are, and I could work around those goals, right? We can figure out how to navigate the settlement agreement or navigate your actions to make sure you comply with the settlement agreement, but you also know what you can and cannot do outside of that. So I told you this is a new law in California, that we're always allowed to talk about unlawful acts at work. So it has not been litigated yet. And when I say that, I mean it's a new law, and we just got this National Labor Relations Act update, or the board opinion letter update, recently. So a lot of these have not been litigated yet. A lot of these have not gone through the court system to see what a judge or a jury says of how we interpret this statute. I mean, you've heard my interpretation of the statute. So, and I'm not your lawyer because we don't have a contract, by the way. But definitely talk to other lawyers to see what they think about any of the things I talk about. And so one of the things I always tell my clients is, if you want to go on Oprah, or if you want to really expose the company and share your voice to make sure that the company doesn't act this way again. First of all, there's a lot of things I talk to my client about those statements that they just made. But I tell them at the end, if that's what you want to do, don't sign the contract, because right now this hasn't been litigated yet. So we don't know what it looks like when a company is going to go after a former employee saying that this isn't unlawful. And if an employee, if they're not a lawyer, they don't necessarily know what they are and are not allowed to say on a daily basis if they want to continue talking about a particular topic. So then the company might choose an unlucky person to, number one, maybe rehabilitate the reputation of the company, or two, stop an employee from talking trash that's absolutely not true about the company, right? Now, if a company does that after an employee speaks publicly, there's another thing called an anti-slap suit, or anti-slap motion. That's really what it is. but an anti-slap motion that prohibits the big man from doing that to the little guy. But that's a different topic. But I always tell my clients, you don't want to be that poster child, because number one, you're going to be defending a lawsuit, a defamation lawsuit, or a breach of contract lawsuit within the severance agreement. And when you get sued like that, there's no contingency lawyers that are available for that type of case, because there's nothing to win. You're literally defending yourself, having to use this new law that hasn't really been interpreted by very many courts yet. So there's not many lawyers who have litigated this to trial yet, and saying, all right, we're going to go against XYZ company who is going to have a lot of resources here. Yeah, so I always tell them, if you want to start a blog about it, don't sign this. Don't take the 2 weeks of severance, and talk about this and be free. Don't be restricted by the provisions just for a $2,000 severance. And some people go one way, some people go the other. Now, it'll be interesting to see what happens here, because that former employee likely signed a severance agreement, so he likely signed another document stating that he would not defame, he would not slander, and he would not disparage the company. But then he's also allowed to talk about unlawful acts that occurred at work. And Mr. Beast is an internet sensation, to the point where, is Mr. Beast's company going to be the person who tries to enforce this new law in California? Is their reputation going to be hurt enough where they would want to do that? Or are they going to let the viral moments pass and then move on to the next thing? Only time will tell. But it's interesting to think about companies that are in Mr. Beast's position, which are very notable, very reported on, and there's a lot of public interest engaged in those, versus a smaller company where, maybe their revenue isn't as reliant on millions of subscribers, and what they would do. Would the PR move of trying to enforce a severance agreement against a former employee who is exercising his rights under the California Constitution and California Labor Code, is it worth it? I don't know. And I guess that's what we have to wait and see. But I know what I would do in this situation with these particular facts, but I'm not your lawyer. Unless we have a contract, I'm definitely not your lawyer. So can't really tell you that, and I have to keep that to myself. So you just heard what I thought about non-disparagement provisions, confidentiality provisions, and defamation, slander within the employment law setting. So if you have any questions or general questions that are not specific to you, or if you have any comments, feel free to leave them in the comment section. I'll try to pay attention to this video a little bit, at least, for a couple days, and respond to it. And welcome to my 1 minute take. This is the second part of my 1 minute take series on this particular topic. If you want to know what this 1 minute take looked like when I had a 10-minute countdown timer, but I went 3 minutes over, check out the video right before this, because I think you're going to get different insight on this topic. You're going to get different views or examples of the same types of legal situations. And by the way, the first 6 minutes, the focus was out, so just listen to it. I swear the audio is still going to be good. Well, that's it. Thanks for watching. My name is Adam Juratovac of Juratovac Law, and I'll catch you on the next one. Bye.